Hi everyone, my name is Jade Calver. I own and operate Calver & Associates Canadian Immigration Services. We're a full-service Canadian immigration firm located in the heart of Oshawa, Ontario. Today is part 3 of my 3-part series on temporary visas and avoiding and addressing refusals. Today I'll be talking about addressing a refusal and what to do next if you do have a refusal. So perhaps you've spent many months putting together a temporary visa application, whether it to be a visitor, a worker, or a student. You've applied online, you've waited for months, and then you get the dreaded refusal letter. It can be deflating to receive, and we definitely understand that. So today I'll be talking about what do I do next if I get this refusal letter and how can I address it. Often we can fix these applications mostly because the evidence that you provided just wasn't comprehensive enough. But I'll go through the steps and talk about how we usually address these and what you can do. So the first step, and again if you have time, if there isn't an urgent need for you to be in Canada, is for my clients, I'll always order the GCMS notes, so that's short for Global Case Management System. That is Immigration Canada's client management system. It's where everything is documented on your case. So through an access to information request, we can access those GCMS notes for you. And what happens is that an officer, obviously there will just be the generic code generations in the GCMS notes that say refusal, but then the officer does have to type something in as to why he or she has refused that application. So it usually takes about 30 days to get back from the government, but we can look at the officer's notes and read exactly why they refused the application. This is really helpful for addressing the next steps because it allows us to know why the officer refused the application. If you have that refusal letter, you'll know that it's just a generic application letter that comes back and they just check off the generic reasons, whether it be lack of ties to your home country, your ties to Canada outweigh those to your home country. Maybe you haven't provided enough documentation, whatever it may be, they're fairly generic and it's hard to know exactly why they refused the application. So these officers' notes, they spell out exactly what they didn't like in the application, and it can be really helpful for us to kind of read between the lines with those generic reasons for refusal. So once we have the GCMS notes and we can understand why they refused your application, then we can decide what's next. If we think that the officer has erred in their application of the law or fact, then we can submit what is called a request for reconsideration. This is done directly to the visa office, and it requires us to usually cite case law and to cite the Act of Regulations and the rules of procedural fairness, and explain how the officer has erred in their application of the law or a fact, so they didn't review the facts correctly or they missed something in the application. This isn't always entertained. We have to try and send it in to the local visa office. We send it to the program manager and we ask them to review the application again. Sometimes it works. We've had some success with some visa offices doing this when there's been a refusal. And then what happens is that they will often reverse the decision and say, you know what, you're right, we're sending it to another officer for review. They review the application, and then what happens is that the application is approved. If we don't think that you have a strong case for reconsideration, so if you provided the bare minimum of documentation required and the officer just didn't have enough to go on, that's, again, as I said at the beginning, usually why these applications get refused to begin with. So what happens is that we use the GCMS notes and the officer's reasons for refusal to inform our new application. So in that refusal letter, they'll say, you're welcome to reapply if you think that you meet the criteria. So that's exactly what we do. We put together a new application and then we make sure this application is really strong. We include proof of ties to your home country, proof that you have enough money, proof that you'll go home, everything that I've gone over in my last 2 videos as part of this series. Because we have those officers' notes, we can specifically address them in our submission letter We can address it using case law as well and explain why the officer was wrong in using that reason for refusal, or maybe we are including additional documentation for the officer to consider as evidence in the application. And then usually, most of the time, these new reapplications with stronger evidence are successful. Lastly, and then if this isn't successful, what has to happen is that you can appeal a negative decision to federal court. So it's important, again, if you are applying for temporary residency, we always recommend that you do seek representation on your applications, because at the end of the day, if your application is appealed to federal court, you do have to show that the officer erred in their review of the evidence before them. So if you don't provide enough strong evidence up front, then you don't have a case for federal court. So again, these are just a few things that you can do to rectify a TRV refusal, whether it be for a regular TRV, a study permit, or a work permit. If you are having issues either preparing an initial upfront application, or you have a refusal and you'd like help to address the reasons for refusal in a new application, we're happy to help. You can book an appointment with us online, and we are at calverimmigrationservices.com.